You've probably heard that forming an LLC protects your assets, but if your LLC is based in California, that protection might not be anywhere near as strong as you think. Most business owners assume that if a partner gets sued personally, the company is safe. But in California, a creditor can sometimes reach inside into the LLC, take control of the partner's interest, or even force a sale of the company's assets. I'm Ali Talai, an asset protection attorney here in California, and I help business owners and real estate investors build structures that actually hold up when things go sideways. And in this video, I'm going to walk you through how California's charging order rules really work, why the state you choose for your LLC matters far more than people realize, and the hidden risks, including legal loopholes that allow creditors to attack your company directly. Most people believe an LLC is an LLC, that the protection is the same regardless of the state. But that is simply not true. In most cases, the state where your LLC is formed determines remedies a creditor can use when they come after you personally. Some states shield your LLC interest extremely well. California does not do that. California gives creditor access to remedies that most business owners never see coming. When your LLC is formed in California, you're automatically playing defense in one of the least protective jurisdictions in the country. Let's start with a scenario that has nothing to do with your business. Maybe someone slips and falls at your house. Maybe a car accident leads to a judgment against you personally, or maybe you sign a personal guarantee and it didn't go as planned. Whatever the reason, you now have a personal judgment with your name on it, unfortunately. Even though your business didn't do anything wrong, your LLC interest becomes a target. In strong states, the creditor is usually limited to a charging order. That means they can only wait for distributions, and usually they have no control, no voting rights, no ability to liquidate your company. But California does not limit creditors to that mild remedy. In California, a charging order is only the first step. California law allows something far more dangerous, which is called a judicial foreclosure of your membership interest. A creditor can ask the court to order your membership interest sold at auction. Whoever buys it becomes the new economic owner and collect distributions indefinitely, even after the debt has been paid. California Corporation Code Section 17705.03 specifically allows this, and once a creditor can sell your entire ownership interest, your LLC stops being a protective tool and becomes exposed asset. California courts can also issue broad charging orders, giving judges much wider authority. A judge can freeze distributions, require detailed financial reporting, restrict transactions, block property sale, or supervise company decisions. This pressure doesn't just affect you, it disrupts everyone else in the LLC. If that wasn't enough, on top of that, California allows equitable remedies such as reverse veil piercing, constructive trust, and alter ego theories. These allow a creditor to go after the LLC itself when they believe justice requires it. Strong asset protection states do not allow this. California embraces it. This is why California LLCs, especially single-member LLCs, are among the least protective structures for owners facing personal litigation. If your LLC has one member or the only members are you and your spouse, you are in the danger zone. Courts routinely say that because there are no innocent partners to protect, creditors should have more access. That makes judicial foreclosure and aggressive charging orders much more likely. I had a client whose Airbnb was held in a single-member California LLC. After a personal lawsuit unrelated to the business, the creditor obtained a charging order and asked the court to sell the LLC interest. The judge was ready to approve it, and that is definitely not something most people think when they're signing up for the LLC. They think that their LLC is going to protect them, but unfortunately, in many cases, that is not the case. Another misconception I hear constantly is the belief that you can operate entirely in California but somehow import another state's protection by forming your LLC elsewhere, like Wyoming or Nevada. And some people take it even further by forming offshore LLCs in places like Nevis or Cook Islands. Here's the truth. When the conduct, the assets, the harm, and the people involved are all in California, a California court will apply California law. If the tenant slips and falls in Los Angeles, the judge is not going to pause the case to research Cook Islands law. If your entire business activity happens in California, filing your LLC in Wyoming or offshore does not move the lawsuit out of California. California will treat that entity, even if it's formed offshore, as a foreign company doing business here, and once you are in California courtroom, California rules will apply. Offshore structures only provide real asset protections when the assets themselves are offshore or movable. Offshore jurisdictions that do not recognize U.S. judgments can work extremely well for liquid assets like cash, brokerage accounts, or digital assets, but real estate sitting in California cannot be moved offshore. That would be nice if you could. A business that is operating in California cannot be relocated offshore by filing paperwork. The judge, the property, and the jurisdiction are all here, so California law will control. Using an offshore LLC to own California real estate doesn't give you offshore protection, it gives you offshore fees. There is a critical distinction most people and many attorneys miss. There are internal lawsuits, inside liability, and external lawsuits, outside liability. An internal lawsuit happens inside the business or the property. Let's say a tenant falls and there is an injury, a contractor dispute, or a claim tied directly to the property. In those cases, the entity that owns the asset is sued, but plaintiffs rarely stop there. Their lawyer often tries to pull you in personally by alleging negligence or mismanagement because they want to reach your other assets. They want to get you in, get you personally liable so they could go after other assets. External lawsuits have nothing to do with your business. These are car accidents, defamation claims, personal disputes, or anything else that targets you individually. Plaintiffs in these cases also want to reach anything you own, including your LLC membership interest. It is in these particular types of lawsuits that multi-layer structuring makes all the difference. If each property sits in its own California LLC, and that California LLC is owned by a holding company, let's say a Wyoming holding company, you have separated the liabilities. Problem at property A stays in property A, and if a plaintiff tries to reach your other assets, they now collide with Wyoming law at the ownership level, and that friction, the clash of jurisdiction, is often what saves the rest of your portfolio. In states like California, your operating agreement becomes one of your strongest defensive tools. It dictates how your LLC functions, and more importantly, what a creditor inherits if they manage to obtain your membership interest. A properly drafted agreement can require supermajority vote for major decisions, ongoing capital contribution obligations, management duties, and other provisions that a creditor or bankruptcy trustee cannot fulfill. These limitations prevent them from stepping into your shoe or forcing liquidation. This isn't just paperwork, it is truly a strategy. And this is where I take the operating agreement one step further. A well-drafted operating agreement can include what is called a poison pill provision. The idea is simple. If a creditor, a judgment holder, or even a bankruptcy trustee tries to take your interest in the LLC, the moment that transfer happens, even involuntarily, your membership interests disappear. They don't get to vote. They don't get to manage the LLC. They don't get to get access to the records of the LLC. They don't get to control the LLC. Their entire claim automatically shrinks down to a tiny economic interest with no power behind it. In the structures I build, if someone tries to seize your membership interest in the LLC, the operating agreement can automatically strip out the voting rights, convert that interest, the voting right interest that you have, converted into a non-voting membership interest, almost worthless economic slice, and return all management and control back to the LLC. The creditor is left with something they can't really use, they can't control, and can't really leverage. That makes the interest incredibly unattractive for them to pursue, and that is the goal. We're trying to make your company such a bad target that the creditor has no incentive to keep fighting. The goal of asset protection is to make it more difficult for them to get access to a valuable asset, something that they would really want to have. And by placing your property inside of an LLC, by having the proper operating agreement, we could make the asset less desirable for a creditor to try to go after. This poison pill approach works beautifully in the states like Wyoming, where charging order protection is already strong. And even in California, where we live, which is a much more hostile environment, these provisions dramatically reduce the leverage a creditor or a bankruptcy trustee has. They think they're getting something valuable. Instead, if they pursue, they get a diluted economic stub with no control. This is one of those advanced planning tools that most LLC owners never hear about, but when used correctly, it can be the difference between losing your company and keeping full control of it during a lawsuit. In states like Wyoming, Nevada, South Dakota, Alaska, the charging order is the exclusive remedy. Creditors cannot foreclose your membership interest. They cannot force a sale. They cannot use equitable remedies. They must wait, often forever, for distribution that may never come. This is why we often place a Wyoming holding company above your California entities. It offers the strongest available protection for your membership interest while still allowing you to operate in California. If your assets and operations are in California, forming out-of-state LLC will not protect the underlying conduct or the California-based lawsuit. But an out-of-state holding company may still protect your other assets when a creditor is trying to collect against you personally. So the strongest structure is usually a combination of multiple strategies. Let's say you have separate California LLCs for each property or business. You have a Wyoming holding company for ownership level protection with a customized operating agreement with all the provisions that you need to have in there, like the poison pill provision, connecting everything to an irrevocable asset protection trust, and having proper insurance as your first line of defense. Combined properly, these layers create a system that is extremely difficult for creditors to penetrate. California is one of the weakest states for LLC protection, but with the right structure, multi-member LLCs, Wyoming holding LLCs, strong operating agreements, irrevocable asset protection trust, and proper insurance, you can build a defensive system that works when you actually need it. Now that you understand how vulnerable a California LLC can be, here is my question. What happens to your wealth once your children inherit it? Can their creditors take it? Their spouses, the lawsuits they get pulled into, can all the inheritance be taken away from them? My next video answers that exact question. The video is called How to Protect Inherited Wealth from Your Kids' Creditors in California. If you want your legacy to stay in your family's bloodline, don't want to miss the next video. I look forward to seeing you over there.